Those are the four documents: your irrevocable trust, your will or a pour over will, your financial power of attorney or your durable power of attorney, and then your medical power of attorney, or like I said, healthcare power of attorney, healthcare directive. It depends on what state you're in. Those are the four documents. That's the foundation of everything else that you will do as you plan for yourself and your spouse and your family.
Hello there, everybody, and welcome to another episode of the Orthopreneurs Podcast. Today is going to be a very interesting topic, maybe make some of you a little uncomfortable. But first, let's welcome today's guest, Trevor Kuresa. Trevor, welcome.
Hey, thanks for having me.
It's my absolute pleasure. For those of you who may not know who this man is, he is a dental attorney, but it's so much more than that. He helps. Today, I really want to talk a lot about the kind of things he helped me with, which are estate documents, wills, trusts, those sorts of things, the kind of stuff that a lot of people, would you agree, tend to avoid and maybe make a few mistakes with?
I would agree, either avoid or never ever think about. So,
yeah. I guess I'm going to start with a question for you in just a moment. But first, do you mind giving everybody that 60 to 90 second background information about, how did you end up being where you are right now?
Yeah. So I was in the JD LLM and tax program at Northwestern. So I graduated from law school in 2011. I started my career as a tax attorney, working in Chicago for a large law firm. I then went to Deloitte & Touche for 6 years, where I did primarily international tax and transfer pricing. And after 8 years of being a tax attorney, I wanted to kind of branch out. So I went to a law firm here in Utah, where I did primarily mergers and acquisitions and corporate counsel to small companies. And that's when I primarily started working with orthodontists. I'm currently the deputy general counsel of Crumble Cookies.
We all love Crumble Cookies. I just want to say.
Yeah, so that's my 9 to 5 job. What ended up happening when I came in house, I just kept getting phone calls from orthodontists, like weekly. And I kept referring them out to different people, and they kept calling me back saying they needed more help and they couldn't find, a corporate attorney who had tax experience, who also understood the, orthodontist industry. So finally, I just started taking clients, more or less on the side. So what I tell people is from 9 to 5, I'm a cookie attorney. And then, after that and on the weekends, I'm an orthodontics attorney.
Are there some good cookie law stories that you're not allowed to tell?
Actually, right now we have some cool ones, but nice. You'll probably see those in the Wall Street Journal in the next year or two.
Okay. Well, here we're talking about cookies, and over your shoulder is a picture of a donut. So we're not even gonna get started with that a little bit. The conspiracy begins. So let's start first with an area where you probably want to start. If I'm let's start with the two extremes. Okay. Let's start with that young doc, came out of ortho residency. They're somewhere around the age of 28 to 30 years old, right? Somewhere in that neck of the woods. Maybe they're married, don't have any kids yet necessarily. I guess, let's go down this permutation: single, married with kids. Are there different needs at each level? Like if you're single, do you really need a will? Do you need to care a whole lot? I kind of know the answer, but I'm feeding you one here. If you're single, married, or married with kids, is that all the same, relatively speaking, when it comes to what I need to do?
I think so. Now, the fact that you're an orthodontist, like I said, most orthodontists that I work with own their own business. So it's one thing if you're an employee of a company and you're single and maybe you have a couple $100,000 in assets. What a lot of people don't know is the state actually writes your will for you, and it's by statute. So if you die and you're single, the assets are going to go where the state statute says, which is usually to either your parents or your siblings, right? Yeah. Where I would be concerned with an orthodontist who's 28 and single is what's going to happen to your business assets. Maybe you're a partner, in a partnership? How is that going to play out? And so that's where I would be primarily concerned with an orthodontist who's single. Obviously, an orthodontist who's married with children, I would advise them to have their estate plan in place. Definitely have a will, because their wife and their children, they need to be taken care of.
And so you said the word will. So let's go down that one a little bit, because I've learned a lot working with you. And again, I have no financial interest in anything that Trevor does, but I will tell you, I want to recommend him very highly, because what he's done for me has been really good. And I have to say on the side, and he's very affordable. I just want to say that out loud. Not that it matters. You want the best, not the cheapest. But in this case, you're going to get a really good value for what you're getting. And he's really good. So you said will. Let's talk a little bit about, I know what a will is, but let's just explain to everybody what a will is and why it matters. And then we're going to talk about, probate, trust, setting up a trust, executors, like all the little things that go along with a will that we have to be careful with, that I've learned from working with you. So first things first, what is if the state writes your will for you, why do you need a will? Number one. And then we'll start there, and then I'll ask a couple of questions about that.
Yeah, if the state writes your will for you, but it's very generic. So usually under most states, it'll say if your parents are alive, then it goes to your parents. If you have living children or a spouse, it goes to them. You may want, something different, or you just might want to be specific as to who receives assets under your will, right? So you might say something to the effect of, I'm speaking of personal experience. I would like my house to go to my brother, but I would like any cash, stocks, bonds, things of that nature to go to my siblings. Okay. Because I have this specific need where in my family, my brother, he would really benefit from having my house, and my other spouses who already own homes, or my other siblings who already have their own homes might, want cash, something like that. Right. So when you die, a will is what is given to the court or the state that tells them what your wishes are and how your assets should be allocated.
And, it's a pretty good explanation of what we kind of already knew, right? And so the next question is, God forbid, something happens to me tomorrow. Who knows, what steps should I know to make sure somebody knows where my will is? Who has the will? Who do they contact? Like if I just passed out tomorrow, walking down the street, sorry, Glenn has unfortunately expired. How does the will come into play? Are there steps that people should take that are mistakes that people aren't usually taking to make sure that what they want is actually known?
I can just tell you what I do, and I can tell you it's the same thing that I recommend that my clients do. I keep both a hard copy of my will at home in my desk, and I keep an electronic copy in my Google Docs. Once a year, I have in my calendar to email my will to my mother. My father passed away, my siblings, my wife, and anyone else who I think should have it. So this would be my personal attorney and my financial advisor. So this is once a year. I just put it in the calendar. As soon as it pops up, I just send it. Now, what this does, it ensures that A, that they have a copy of the will, and B, that they know that it hasn't changed. And so if I die anytime after that, during that time period, everyone is on the same page as to which will is active, because you can have more than one will. Technically, like when you sign a will, there's always this language that's saying you're revoking all prior wills. So you'll see from time to time litigation in which families are fighting or arguing over which will is actually a valid will. So I like this because once a year it just lets everyone know, here's a copy of the will, here are the provisions, and I hope to live another year, but if not, take care, right?
And happy birthday, Mom.
That's right.
It's got to be distressing for your poor mom to get your will in an email, but I get it. I totally get it. And so who makes sure that the wishes in your will are carried out? What is the official name of the individual who makes sure that, I want my brother to get my house, I want my siblings to get my cash? Who makes sure that actually occurs the way it should?
Yeah, so they have different titles in every state. The two most common titles are executor and personal representative. So in your will, you name an executor or personal representative of your estate, and it is their job to follow the interstate succession laws of the state in which you are resident or in which you die, and to make sure that the wishes and the desires as expressed in your will are carried out.
Got it. And so you and I have talked a little bit about something called probate, right?
That's right.
And so if you want to talk a little bit about probate and what it is, how someone ends up in probate and what happens, and then last but not least, how can we avoid going to probate?
Yeah. So probate is a court supervised process by which a deceased person's creditors are paid and the decedent's property is distributed to the persons who are entitled to it. Okay. So um, there are attorneys that that specialize just in probate. And so what happens is at your death, if you die with a will, you take it to the courthouse and you open what's called a probate. And the judge will ask to see the will. You submit the will to the judge.
And just so we're on the
And
same page, I should die, of course, God forbid, and my mother has a copy of my will, right? She goes down to the court
correct.
at this point. And my assumption is that there's better ways to do this, but that she takes the will down to the court and now it's in probate.
That's right. That's
Okay.
right. And the whole purpose of the probate court is, like I said, twofold: to pay any creditors. So now, if you have any creditors, they need to come, and we call it lining up at the courthouse. So you can imagine in old times, right? They're just in this line of creditors, right? And also the assets of the decedent are going to be submitted to the court. And then what the judge's job is just to look at the assets, look at the creditors, and decide who is going to get paid. After creditors are paid, then it's the judge's or the court's responsibility to send the assets, any remaining assets, to the beneficiaries under the will.
And so it sounds like a pretty reasonable place to be, but I've always heard that probate is not a place you want to end up. Is that incorrect?
No, that's correct. You want to avoid probate at all costs. There's three primary reasons. Number one, it's very time consuming. Even Utah has like this expedited probate statute where if you meet certain requirements, this is usually for people who don't own real estate at death, or if they do own real estate, they have equity of, or they have total assets of less than 100,000. Even a small probated, estate like that is going to take 2 to 3 months. In my experience, for an orthodontist, you're looking at anywhere from 9 to 15 months to probate a will. And so that's number one, it's time consuming. Number two, it's expensive. So your executor is probably going to have to hire counsel to help them with the filings, to help them deal with the creditors, to help them get the assets to where they need to go. No one wants to pay those fees, right?
Right.
And finally, a will is public. I would say the biggest problem with the will from an orthodontics perspective is all of their personal holdings, whether it be bank accounts, financial dealings, real estate holdings, that immediately becomes public information. And for someone like me, who's more of a private person, I wouldn't want that in the public domain.
I don't blame you. And I feel the same way. So how does one avoid probate?
There's three ways to avoid probate. The first one would be how you title your assets. Okay, so upon death, assets held in your individual name are subject to probate.
Okay.
But assets that are held what's called a right of survivorship are not entitled to probate. So let's say most people own their home with their spouse in joint tenancy with right of survivorship. So what that means is if one of the spouses dies, the title automatically transfers to the surviving spouse. So that is one way in which you can avoid probate. You see this a lot with bank accounts. Like at Wells Fargo, that's where I do my banking. I have what's called a POD, a payable on death. And what this is I went into the bank, I met with a banker, and I signed a piece of paper saying, on my death, I would like my bank account to automatically transfer to my wife. And so that is one way to avoid probate. The reason being is because those assets are not in your individual name. So there's nothing to be probated, right? A second, and this is, a more common way, is that an orthodontist or, any individual can create what's called a revocable trust. Now, a revocable trust is just like it sounds, it's revocable. So it can be changed, canceled, modified, terminated anytime. But any assets that are titled in the name of the revocable trust will bypass probate because they're not titled in the name of the decedent. Okay. So remember, property that is titled in the decedent's name at the time of death must pass through probate, unless it was held in joint tenancy with right of survivorship or subject to a beneficiary designation. That's what I was talking about, that POD account at Wells Fargo. Those are known as beneficiary designations.
I always seen bank accounts back in the day that always had, or an investment account that would come to me, and it always said, joint JT, WROS or something like that.
That's right. That's right.
Which is my joint tenancy with right of survivorship, right?
That's right. That's right.
And so I learned that years ago, but for years I could not understand what those initials meant. And that means basically that those will avoid probate because it's an account open to basically go past it, right?
That's right. And but some assets, you can't do that. For example, if you're a 25% owner in a corporation that runs your orthodontics practice, right? You might not have a beneficiary designation. You can't hold that in joint tenancy with right of survivorship. So in those situations, you want to title those in the revocable trust, because property that is held in a revocable trust is not titled in the name of the decedent. It is titled in the name of the trust, and therefore it is not subject to probate.
Cool. And so going through a few of the things that we've got, right? So you've created your revocable trust, right? Which I guess technically houses your will, right? Is that true? Or
no, those are two
assets.
Yeah, just the assets. They're two.
So the will will direct everybody towards the revocable trust or to the assets that are held in. So I guess the will tells everybody what they get. The revocable trust holds the assets and is basically a way of avoiding probate court.
That's close.
Oh,
so yes.
Man.
So the will is usually called a pour over will.
Okay.
And what that does is the will just says, hey, if any assets are in the name of an individual at death, just send them over to the revocable trust.
Got it.
And then the revocable trust has all of the who gets what provisions.
Got it.
Now, this is nice because the revocable trust, like we said, is a private document. It's not public domain. The court doesn't get to see it.
Got it.
So, if you want to give, most people just give to their children equally, but maybe 10%, 15% of the families I work with, they have at least one drug addict or one child who has some sort of addiction. And we always have to draft special provisions in the trust, where 3 of the 4 kids, they have a lot of freedom with the assets they're going to get. But this one kid, he needs a little bit more help because he might get into trouble. And so, but we want that private, right? We don't want that out in the public domain. That would be fairly embarrassing. And to the extent it's not embarrassing, it's no one else's business.
Exactly.
Right.
And, this is personal stuff. Nobody needs to know about this.
And I always like to use this example of real estate. Let's say an orthodontist owns 3 pieces of real estate. One in his or her individual name, one with joint tenancy, right of survivorship, and one in the name of the revocable trust. And then the orthodontist dies. The real estate that was held in his or her personal name has to go through probate. The real estate that was owned with joint tenancy with right of survivorship automatically transfers to the other person. It's usually his or her spouse. And the real estate that's owned in the revocable trust continues to be held in the revocable trust until it is distributed to the beneficiaries of the trust, usually the surviving spouse and the surviving children.
Got it.
So that's one way to think of it. Now, the only caveat I have to make is in that first scenario, the real estate that's going to go through probate what's going to happen is you're going to take the will to the court, say, this is our only asset, it's probate, it's title in the name of the individual. They're going to go through the whole process. And at the end, under the terms of the pour over will, it's going to get sent over to the revocable trust. And so I like to use that example because I think it's intuitive. A lot of people get it. As you might have, you've probably picked up on this. And Glenn, this is actually where I'm at in working with your financial advisor. So we go through this process where we set up your pour over will and we set up your revocable trust. But really, that's only half of what we have to do, right? Because now we have to inventory all of your assets and we have to start transferring assets over to the revocable trust or in joint tenancy with right of survivorship or creating beneficiary designations. So ideally, in a perfect world where, we have an orthodontist who's just on the ball, right? They will die with zero assets held in their individual name, and they will all be titled either in the revocable trust or in joint tenancy with right of survivorship, something like that. Inevitably, that doesn't happen. Maybe they buy a car a week before they die and they buy it in their individual name because they're at the dealership and they never really thought about it. Something like that, right? So inevitably, they always have some assets that are titled in their individual name, but we try to get the majority of the assets out of their individual name and into titling that can avoid probate.
So I know this is going to sound like a stupid question, but maybe others listening are thinking the same thing. If the joint tenancy with right of survivorship automatically passes to the spouse, and then we're talking about a first to die sort of situation here, and we've got a revocable trust, what does it matter which is which? If everything that's joint tenancy is in my revocable trust, it's going to that person anyway, isn't it? Or are there tax implications related to how it transfers through?
So there's two things. So let's say we have an orthodontist and we'll just say it's a him for this purpose. And
let's just say his name is Gren.
Gren.
Grenn.
So we'll go back to the real estate. Okay. So Glenn, you own real estate with joint tenancy with right of survivorship with your spouse.
Right.
You pass away. The titling automatically transfers to your spouse's name. Now it's in her individual name. Now, hopefully I have a good enough relationship with your spouse to where I would say, hey, we actually need to get that in your spouse's revocable trust now, or we need to get it with joint tenancy with right of survivorship with your children or whoever you want to pass that real estate on to.
Right.
So that's actually outside of your trust. We think about the real estate that was titled in your revocable trust. On your death, that stays in there and it's locked in. And so that is now an asset of the trust, and it can only be distributed pursuant to the provisions of the trust. So I'll give you an example. I was working with an orthodontist this week, and they had a very frank conversation with me. The wife kind of runs the shows. She's really savvy. She has a finance degree and she's an MBA, where the husband is an orthodontist, where he has a kind heart. And she told me, under no circumstances do I want my husband making any beneficiary designations, because he will give away all of his money and it's just going to be terrible. So what I said is, okay, any assets that are titled in joint tenancy with right of survivorship, I want to move that over to the wife's revocable trust.
With his permission, of course, correct?
With his permission, of course, correct, yes. And we're going to name your two oldest children as co-trustees of that trust. And the whole point of that is, if she dies first, she feels more comfort knowing, okay, everything is in my revocable trust and my two oldest children are going to be managing those assets, and they're going to make sure my husband, doesn't give it away, because bless his heart, he's a kind man, right? And he's always, trying to give to charity and things like that. And so she just felt,
what a terrible human being he is.
Yeah.
Trying to give it away to charity and stuff. Right. No, but it sets up a very, very interesting situation that Mr. A and Mrs. A are married, or let's in this case say Dr. and Mrs. A are married. She feels, and he agrees, that he's too charitable and doesn't trust himself, and she doesn't trust him. And so they put it into her revocable trust with the children as co-trustees.
Yeah.
She passes away first. He has no rights to say where the money goes, right? Because the kids are the co-trustees.
That's
so
right.
He's basically now been put on an allowance, if they so see fit, by his children, rather than it passing through to him like most states, because he's the second to die.
That's right. That's right.
That is a very interesting and strange insight into that relationship. I'm just leaving it there, Trevor.
But you can see the flexibility that we have, right? So
right. Can the children at that point, as trustees, transfer it back into his revocable trust if they all agree that that's the best thing? If he says, look, mom was crazy. You guys know mom was crazy. Come on. She always worried about me. And now that she's gone, let's move all the money over to my revocable trust. I'm not giving it away. You'll have an inheritance. Don't worry about that. She just overestimated. And the kids go, okay, Dad. Are they allowed to move that from one revocable trust back into his revocable trust?
So he is a beneficiary under the trust, so they can move any assets to him at any time.
Okay.
I would strongly encourage them not to, because the intent and the wishes of their deceased wife or mother were clear.
Okay.
And so I would strongly encourage them not to do that, and advise them of their fiduciary liabilities and things like that. But
like the drug addict's son who says, no, I'm cleaned up. I'm all good.
Yeah,
just give me all my money. I'm fine.
And I'm in a way, it always pains me to work with families who have children with addictions, but professionally it's been great, because you really get to be creative, and you really get to see the flexibility in these instruments and how we can work together to help those children. And so if we can work together to help, a drug addict, we can work together to help really any situation. Right. So the key is just to be clear in your intent and to have a good idea of what you want.
Excellent. So before we jump on to the next topic, because I think we've hit this one pretty well, just high level, two things. Number one, biggest mistakes you see when it comes to wills and trusts, if there are any. And number two, for those of us with older parents, obviously we want to have a frank discussion with them to find out, wills, trusts, and what have you. But we'll get into more of that in just a moment when we start talking about medical-based stuff. But best practices or mistakes you've seen when it comes to wills and trusts?
Biggest mistakes is they just don't get around to it.
Okay. So as long as you do it, do it.
That's right. That's right. And then we're stuck in this long expensive probate process, and the rules of interstate succession, depending on their state. Best practices are what I talked about. So we get it done. It's clear. It's convincing. And then once a year, we revisit it to make sure that everyone is on the same page and understands, their responsibilities and also what will happen on someone's death.
So now going on to parents, right? I've got parents who are a little bit on the older side, right? Dad's 81, mom's almost 80. We've had some good, frank discussions about, what documents do you have? What do you want to do? When you pass, who do I call? Who's your attorney? Who's your accountant? Like all the basics. And we keep them in a Google shared drive that's, among the family, like you suggested. But what documents should I make sure that my parents have? Because I know there's power of attorneys, there's durable powers of attorney, there's medical power, there's living wills, there's all these sorts of things. It can make your head spin. What are some of the things that I know we should all have, but even more importantly, to make the transition a little less difficult when your parents or loved ones pass? What are some of the things that should already be done, ready, so that, God forbid, they're not dead? I mean, obviously, God forbid they're not dead, but they're in a vegetative state, or, I've seen this in my own family. What suggestions do you make for most of these scenarios?
Yeah. So luckily I'm going through this right now with my wife's family, her grandparents, actually. So the first thing I did is I had them create in a Google shared drive a list of their assets and the title. And almost all of these assets, well, all of them were either held individually or with right of survivorship, right? So then I said, okay, now let's get your will and your revocable trust together. And I also did what's also called a financial power of attorney. And so we had there's kind of two goals here. One is obviously to avoid probate, like we discussed. So let's get as many of the assets as we can, either in the revocable trust or with a beneficiary designation, or with the rights of survivorship. So we went through the process of changing the titling. The second thing we did is we created a financial power of attorney. Now, what a financial power of attorney does is, in the event that grandma or grandpa is incapacitated, it gives the agent under power of attorney the right to act in their name for financial matters. Okay, so what I see, the most common example that I see is about once a year, I will get a phone call from, a business owner, and they will say, the business owner, got hit by a car, or, is in a coma. It's always something where they're incapacitated in the hospital and there's no one there to sign payroll. So we have 55 employees and we can't authorize payroll because he was the only one here who was authorized to do that. And so that's where a financial power of attorney will come in handy. Because if he or she had a financial power of attorney at the time of incapacitation, the agent could step in and act in all matters. So
When you say
that kind of,
the agent,
yes, the agent.
who
So
is
a
the
financial,
agent?
so it's named in the financial power of attorney. So in my
Okay.
financial power of attorney, it's first my wife, second my mom.
Okay.
I believe my personal attorney is my third. It's just whoever you trust most. Most
But
people trust their spouses.
But at that
Um,
point, God forbid the person gets hit by a car, the agent happens to be the wife. She just she just holds up this piece of paper basically and says, "I'm here. I'm signing on all the checks
that's right.
as if I was him."
That's correct. That's
Okay.
correct. Okay.
So, is there any
So
concern about somebody running amok with this? You go into the hospital for a gallbladder operation. You're there for 3 days, and they pull out the power of attorney and go, "He's incapacitated. I'm running the show now." Or does that not really happen?
I've personally never seen it happen. For people who are worried about that, we do have what are called springing powers of attorneys, which means that they can only come the agent can only receive the authority under the power of attorney if two physicians declare the individual to be incapacitated.
Got it.
So we've done things like that, but really, yeah, I mean, once you hand over a power of attorney to your agent, you're giving all the power. So choose wisely.
So again, just to be clear, the financial power of attorney, do you have to be incapacitated for it to be used? Or, again, if you've got that, and again, I don't live my life around the thought of bad operators, but it begs the question. You have $10 million in the bank or a brokerage account. Can this agent present this document to, say, financial institution 87, I'm just making up a name, and say, "My husband signed this financial power of attorney. I would like to withdraw all my money." Does somebody verify that the individual is incapacitated, or is it not really based on incapacitation? It's simply, I've got a document which gives me rights whenever I want to go grab what I want to grab.
It depends on how it is drafted, but I would just say the short answer is yes. The
Yes,
short answer is they do have the authority to act in
got it.
your capacity. Yeah.
So
So you want to make sure whoever you name under there is, like I said, there's steps that you can take to add layers of protection.
right.
Um, but now you're depending on a brokerage company to, let's say it is a springing power of attorney, and now you're relying on the brokerage company to A, read it, right? And B, to care, hey, do you have this statement of incapacitation signed by two physicians? I mean, if they're willing to go that far, why wouldn't they just forge it? Right. So
Right.
I do think that, yeah, just be careful. It's a big deal.
Yeah, the only reason I bring it up is because just recently I did an interview with the American Association of Orthodontists General Counsel and Trey Lawrence, and great conversation, great talk. But I understand the value of the proof, if you will. So if you have $10 million and say company number A doesn't do the required due diligence necessary, it's on company A. The person still gets your money, but at least, you know, if the person forged 2 signatures and is later on to be found forged, they're going to jail for that. So at least it offers, it may not solve the initial problem, but eventually long term, hopefully, you can recover the assets and the person is prosecuted effectively. But I agree, everything you said makes perfect sense. That's why I asked it. But what about medical power of attorney, right? God forbid that same person's hit by the bus, they've got a trach, they're out cold, they're sitting in a ICU, and decisions have to be made about their medical future. Do you recommend that people get a medical power of attorney done?
I absolutely do. And medical power of attorneys are, the name of them is different in every state. So for example, in Utah, where I reside, they're called healthcare directives. In some places they're called healthcare power of attorneys, medical power of attorneys. And just like we discussed, as a power of attorney, you are designating an agent to act in your name in the event that you are incapacitated, and to make decisions for your health care. Oftentimes in these documents, you can give your wishes. So like, for example, in my healthcare power of attorney, my wife, Danielle, is my agent. And I have instructed that if I have been evaluated by 2 separate physicians and both have agreed that I will be in a vegetative state for the rest of my life, that she can pull the plug. And so I felt like I needed to put that language in there to give her, you know, I don't want her making that decision on herself. I'd rather she read my own words and then give the okay. But really, in the times that I've had to seen this used, it's when someone is incapacitated and the physicians are asking the agent, we have, you know, A, B, C diagnosis. Here are different treatment plans. Which one do you do as the agent? So, but yeah, it's both healthcare decisions and end of life decisions. And, you know, I think this is really important. The problem with not having these power of attorneys is that in the event that one is needed, so you need to go get what's called a court supervised conservatorship if you don't have a power of attorney in place. So upon incapacitation, you have to go to a court to appoint a, you know, conservatorship, and that's time consuming, expensive. You just don't want to do that when you're in that sort of a crisis mode. It's easier just to have these in place.
Okay. So what else have I missed? What other documents, if any? I mean, you've covered some really good ground, from wills, trusts, revocable trusts, right? Powers of attorney, medical power of attorney. We didn't talk about a durable power of attorney, or did we?
The durable power of attorney is just another name for a financial power of attorney.
Got it. I didn't know that. I thought there were 2 different documents. So is there any other document that commonly, I'm not saying specific weird situations, but is there any other document that if someone were to come to you, you'd say, you know what, you should have this as well?
No, those are the 4 documents: your revocable trust, your will or a pour over will, your financial power of attorney or your durable power of attorney, and then your medical power of attorney, or like I said, healthcare power of attorney, healthcare directive. It depends on what state you're in. Those are the 4 documents. That's the foundation of everything else that you will do as you plan for yourself and your spouse and your family.
So weird, because those are the 4 documents you got for me. It's so weird how
that. Yeah.
But the number one thing, and I'm guilty of it right now because I have about 100 pages of documents, maybe more, in front of me for me and my wife, is to get them signed and notarized. And I think you told me that the best thing I can do is get them signed and notarized. They don't have to be notarized, but it only helps us in court because it means that we know that we signed them. And then copy them and send you, my attorney, a copy of the actual signed and notarized documents so that you've got a record. So if anybody ever wants to dispute it, you've got a really good record in front of you, correct?
That's right. That's right. Yep.
And so the number one step, there's 2 steps involved. Number 1, get the documents. Number 2, sign and notarize them.
Yes. And you would be, I have so many stories of how hard it was to get people to sign and notarize these documents. But
I'm one of them. I'm one of them. It's been weeks, Trevor. And this is an excuse, but here's the difficult part. The bank won't notarize our will or trust. They will only do they won't do a will. They'll do any other document, but they won't do my will or my trust. So I have to find an attorney that I have to get to who will do it. And that's a challenge, is finding an attorney who you can call your regular attorney, but many times your attorney is not in your state. You're using a business attorney, or like Trevor, you're in Utah and I'm in Dallas. So that's the biggest hindrance, is finding somebody who will actually notarize my will and my trust, because the bank won't do that. And so stay tuned, folks. We'll see what happens next. On the next episode, will Glenn die before they're notarized? Now, if that really happens, this is like the greatest episode ever. But I hope it doesn't. So I don't want to end up in probate. Okay, either with my estate or my soul. But I just want to say thank you from the bottom of my heart, Trevor, for being here today. I know you've taken a difficult to talk about subject and broken it down and made it a lot easier. If people want to get a hold of you and learn more, or just talk to you, or find out if you can help them with their documents, what's the best way to reach you? Yeah, my contact information is on my website. It's hibiscuslegal.com. So it's hibiscus, like the flower. Like the flower. Yep. Legal.com. I also have a lot of resources for orthodontists. And I also have a short summary of what is a basic estate plan, and it covers almost everything that we discussed here today. And so if they need a refresher, feel free to go there. It's all free resources. But yeah, my contact information is there, and shoot me an email or give me a call, and we can get connected. Fantastic. And again, thank you for being a part of this. You've certainly enlightened me. And as I demonstrated, even after our once go around, I still didn't quite understand all of it. It's confusing. There's a lot of moving parts. But I suspect that, when someone goes through it, it just makes a whole lot more sense. And thankfully, knock on wood, I've never in my life ever had to deal with a will or a trust or anything like that, because my parents, thankfully, are still around. But I suspect that once you've been through it once, it becomes a little bit easier to understand it. Yeah, that's agree. And that's kind of why, you hire me, right? Because I've been through it, dozens of times. And so I can give you some good examples of what to do, what not to do. And I've been down to the court through probate. And so the goal is just to make it easy on you and your surviving family, and to make sure that everyone is taken care of, protected. We appreciate it, Trevor. And just thank you again for your time today.